Okay, so now is my chance to fire away. And my topic today is don't let your search for the right human impact upon someone's human rights. And full credit to Rebecca for that really clever title, which I plan to reuse probably many, many times in the future. So I'm going to start off by assuming that nobody watching will deliberately discriminate against an applicant on the basis of things like race, gender, disability, or anything else covered by human rights legislation. So my message today is that you need to make sure you're not inadvertently discriminating against people on those bases. I know that sounds a little strange, but the reality is we see this all the time where people have no intent to discriminate against groups that are traditionally disadvantaged, but they have rules or policies in place which have the same effect. A classic example is a workplace that's on the second floor of a building. There's no elevator, there's no ramp. They have a job applicant who's in a wheelchair. And they all realize very quickly there's a physical impediment to them working when the individual says, well, is there any form of accommodation you could offer? Could I work from home, for example? The knee-jerk reaction is, no, we need all of our employees to be here physically, without ever really giving any consideration to whether that's really a requirement, whether you could accommodate them. Similar, we often, so in that case, you may have as well have had a job posting that says applicants in wheelchairs need not apply, even though it didn't really say that, because that's the effect. Similarly, if you have a requirement, if you're in a retail operation, for example, requirement that individuals must be able to work on Saturdays every now and again, you are now preventing anyone who has their religious Sabbath on a Saturday from applying for the job. And again, we often see this, and the response is, that's just the way things work around here. Again, no consideration about whether that's required in 2019, or no consideration about whether they could be accommodated. And the reality is, if you are confronted with this and accused of discriminating and your response is, well, that's just the way we've always done it, that's not going to get you very far. In season 2, episode 4 of Fire Away, I was speaking with Christina Guida about immigration and employment issues, and we indirectly referenced the recent Human Rights Tribunal of Ontario decision involving Imperial Oil. And so I want to talk about that really briefly because it's an interesting example of where citizenship became a factor. In that case, we had the applicant, Mr. Hasib, who was applying for a permanent full-time position with Imperial Oil. At the time, he was an international student at McGill with a student visa. And when he graduated, he would now obtain a 3-year work permit. And we talked about that briefly with Christina. The anticipation was that during that 3-year period, he would obtain permanent residency, and his evidence was that he had every intention of staying in Canada and working here, and he wanted this job with Imperial Oil to be a permanent job. Problem, of course, is that Imperial Oil had a policy in place which said that applicants for graduate engineer positions had to be eligible to work in Canada on a permanent basis. And that's a key phrase right there, because of course, most people, when we work with our clients and we put together employment contracts, there's conditions, and it almost always says the applicant must be legally entitled to work in Canada. And that's fine. That doesn't breach human rights. Adding on a permanent basis may well, and according to the Human Rights Tribunal of Ontario, it does. In this case, it's interesting how it played out. So obviously, Mr. Hasib spoke with some more senior students who've gone through the process and was told, if you tell them you are not legally entitled to work in Canada on a permanent basis, you're not going to get the job. He'd been coached on that. He went for the interview. He was asked, according to the evidence, several times whether he was eligible to work in Canada on a permanent basis, and he lied. He said he was. And not only did he get the job offer, he was actually ranked first among the candidates. Got the job offer, but it had that same condition again. You must be legally entitled to work in Canada on a permanent basis. When he couldn't provide proof that he was, the job offer was rescinded, and Imperial Oil essentially said that you're welcome to reapply if and when you become eligible in the future. So Mr. Hasib brought a claim to the Human Rights Tribunal of Ontario saying he'd been discriminated against on the basis of his citizenship. Imperial Oil defended really on 2 bases. One was that it was a bona fide occupational requirement, and their argument essentially was that they would suffer undue hardship if they had to incur the costs of training applicants only to have them leave when their work permit expired. Their second argument was that the failure to hire him was not because of his citizenship, it was because of his dishonesty. He lied in the application process, therefore they couldn't trust him. Both arguments failed. What the Human Rights Tribunal found was that really what this came down to was that if he was a Canadian citizen, he would have been hired. Because he wasn't, he was discriminated against. And therefore, the Imperial Oil in that case was on the hook for breach of the Human Rights Code. And this is what we often see. We rarely see those job postings that say immigrants need not apply, but we often see policies or rules or requirements that indirectly discriminate against people who are the human rights legislation is designed to protect. And usually it's because the company never really took the time to assess their policies, never took the time to think about whether there could be any kind of accommodation. The response usually is, that's the way we've always done it. So if it's a matter of insisting that people come into the workplace instead of working from home, if it's insisting that they work a 9 to 5 shift as opposed to 8 to 4 or 10 to 6, or insisting that they work on weekends, the reality is that many companies will just say that's the way it works and we can't hire you if you can't do that. So message for today, first of all, hopefully it goes without saying that you're not deliberately discriminating on the basis of grounds like gender, race, sexual orientation, et cetera. That's not only unlawful, it's immoral, so that shouldn't be happening anymore. But more importantly, if you're an employer, make sure that you are not indirectly or inadvertently creating barriers that have the same result. I'm going to encourage all employers to review your hiring practices, hiring policies, and hiring requirements and assess whether they are legitimate in the context of society in 2019. Assess whether exceptions or accommodations can be made for those people who need it. So even though you might require that everyone come into work and be physically present in the office, if someone is physically unable to, can you allow them to work from home temporarily, permanently, or would that really be undue hardship? Remember, the standard for undue hardship is it's a pretty high threshold, and you're going to be on the hook for proving that undue hardship exists. Remember as well that even if the prohibited ground or protected ground under human rights legislation is a tiny part of the reason why you made your decision not to hire someone or to terminate someone, that's a breach of the Human Rights Code. Best example is actually a termination case from a couple of years ago now, where a company had an individual who was documented in performing horribly, didn't meet any expectations, was warned, was coached, was given training, was told if you don't improve your performance, you're going to lose your job. The problem is what led to the termination in that case was him asking for a religious holiday as a day off, being told, no, you can't have it, and taking the day anyway. And then he was fired. And he brought that to the Human Rights Tribunal. And the company said, no, we didn't fire him because of that. He was a horrible employee. His performance was terrible. We warned him. We documented it. We gave him time to improve. He didn't. Therefore, we let him go. And what the tribunal found essentially was that, yeah, there were very legitimate business reasons for letting him go. But the straw that broke the camel's back, so to speak, was him asking for a religious holiday, being turned down and taking it anyways, which is obviously related to a human rights ground. And therefore, that was a part of the reason for termination. Therefore, there is no partial breach. It's all or nothing. And in that case, there was a breach. The company was on the hook for damages. So we see companies spending a lot of time, a lot of money, a lot of resources defending human rights claims because they never took the time to assess their policies and think about whether it may be inadvertently breaching someone's human rights. So I'll encourage everyone to review their policies now. If you're not sure about any of this, if you're an employer, you're not sure if your policies or your procedures or your requirements are defensible, give us a call. If you're an employee or an applicant and you think your human rights have been breached, don't just let it go. Give us a call. As I always say now in our Fire Away episodes, if you think you might need an employment lawyer, you probably do. So don't hesitate to reach out and contact us. Bottom line is in 2019, this type of discrimination shouldn't be taking place. That's my 2 cents worth, and you got it here for free.